Hello everyone, my name is Anisha and today in this video I'll be discussing about voluntary intoxication and some other components of it. So let's proceed. Voluntary intoxication, what do you mean by it? In the case of voluntary intoxication that is dealt under section 86 of IPC, the knowledge factor is same as he was not intoxicated. So the Dutch case rule is also used to describe the manner in which the case will be dealt. The cases show that a person cannot be exempted from the grievous offences even if the defence of intoxication was taken. It says that where the person is not intoxicated, but if the act is done with the particular knowledge and the intention, then he will be prosecuted for the same offence which he would have done without the intake of any intoxicating substance. So in this case we can say that the knowledge and the intention are taken as important factor in the to constitute voluntary intoxication. And if the person is capable of understanding that as to what he has done, or that what he has done has caused an injury to the other person, and knowingly, or that he is in his full senses, then he will be prosecuted for the offences as a normal person, and he will not be exempted for the defence of intoxication. He cannot be exonerated by taking the defence of intoxication, because the intoxication here was totally voluntary in nature. And this section 86 it also talks about voluntary intoxication is not exempted in IPC, and the offence committed by the person who has voluntary intoxicated himself or consumed alcohol will not be exempted. If a voluntary drunkenness will be allowed to be protective shield under the criminal liability, then what will happen? Like this is the context where it was considered that no, voluntary intoxication cannot be considered to be a defense and cannot be used to exonerate the criminal liability of any person who is doing the crime. So further we can say that the ingredients to satisfy section 86 for the voluntary intoxication are that there should be presence of the element of the particular intention or the knowledge. Secondly, he should be influenced by the consumption of the intoxicating substance. Thirdly, the intoxicating substance must be administered to him with his knowledge and not against his will. And that's all. These are the ingredients. And section 86 it deals with the immunity of a self-intoxicated person when he commits an offence requiring a particular knowledge or the intention as a definitional ingredient on the part of the accused. Section 85 it covers all the offences, while section 86 it covers the offences requiring particular intent or the knowledge. Section 86 if we try to understand that what section 85 and 86 is all about, then section 86 is an exception to 85, and the state of intoxication that is envisaged under section 86 must render the accused incapable of forming the specific intent essential to constitute the crime. Talking about the presumption of knowledge, a person who gets into the state of intoxication or voluntary consumed and then he has the same knowledge as that he would have the not been intoxicated, then it will be considered to be voluntary intoxication, and as there was presumption of knowledge. Forcibility test it is used to determine the criminal liability. Every person has the knowledge that consumption of alcohol or ingestion of drugs it causes a loss of control over the mind and the body. So hence any person, if he knowingly consumes or intoxicates himself with such substances, then it can be considered that he committed such rash and negligent act averse to the possibility of losing control, then he actually did that intentionally. it will be presumed in the eyes of law. And by this, if one attracts the charge of deliberate intent by consuming such substances then known to lead to such circumstances, so it will be considered to be a voluntary intoxication and he will be punished under that. Voluntary intoxication, it is in order to constitute it, intention is very much necessary to constitute it, because it plays an important role, because the criminal intention is only something that is punishable under IPC. If the criminal intention is not there, then such act that led to the commission of any crime will be exonerated, and will be a person who is doing that will be exonerated, or the severity, it will be considered to be very less or not grave, as it could have happened with the much more intention that if that intention has been present. So a motive is something that makes a person to form an intention to do that, and the knowledge is something that makes the man aware of the act. So far as the intention and the motive is concerned, it must be gathered from attending the general circumstances of the case and paying due regard to the degree of intoxication. If a man was out of his mind altogether at the time of the commission of the crime, it would be possible to fix him with the requisite intention. But if he has gone so deep in drinking, and from the facts it would be found that he had full knowledge of the acts, then one can apply the rule that a man is presumed to intend and the natural consequences of his act, and the intention is something that is which is prompted by the motive, and the knowledge is an awareness of the consequences of the act. So it will be applied, presumption of knowledge and the intention both will be applied. So according to Dutch courage rule, it is also important, because a person before drinking plans that what he has to do and builds up the courage to do, and this is known as the Dutch courage. This is based on the theory that the person often consumes alcohol to build up the courage, and the drinking causes the loss of causes a sense of self-resistance. It also takes away the capacity to think, and as to what he is doing is illegal. And this rule only governs the principle of voluntary intoxication. This shows that a person has the intention and also earlier plan to do the act. Now regarding the burden of proof, we can say that the burden of proof lies on the accused for the commission of the offence. He has to prove that the intoxication was by involuntary means, and the intoxicating substance was not consumed by him involuntary, and he will also has to prove that he did not have any knowledge of the intention of doing that particular act. The facts and the circumstances also has to be proved that the accused person that led him to commit that such an offence, and to avail the protection of section 85, it is required for the accused to prove that the intoxication was not voluntary, and if he by reason of intoxication lost the mental equilibrium to distinguish a right from the wrong and good, bad, then all these things or the nature of the act committed by him, then in such cases intoxication can be taken as mitigating as well as aggregating factor after viewing that what actually is revealed by such facts and circumstances of those cases. But in order to take intoxication as a defense, the burden of the proof is on the accused to prove that the intoxication was not voluntary one, it was involuntary in nature. So we have understood that intoxication can be considered to be a mitigating as well as aggregating factor. The recent developments regarding this, it also indicates that even if a person is involuntarily intoxicated, the gravity of the offence is very severe, then he will be held liable for the offence. So this is all for today, and I hope you all understood the concept, and thank you for listening.